May it please the court. My name is Matt Thatcher. I represent the appellant, the former wife in this case, Diane Lorraine Purin, and I would like to reserve 5 minutes of my time for rebuttal. Your Honors, this is an appeal ultimately of an alimony award. And the alimony award presents really two distinct areas for the court's consideration. The first one I think is the easiest, and it's a de novo issue of law. The trial court misstated 61.08 subsection 7 when it expressly found in the transcript of the hearing and then reiterated in the final judgment that the award of durational alimony is precluded by statute from being extended. Plain language of the statute says that it can be extended upon exceptional circumstance. I don't know if that's really a contested point, but that is one of the issues that is raised in the appeal, and I think warrants a reversal at the very least on that issue. Then we come to the issue of the overall alimony award. The trial court abused its discretion in this long-term marriage by not awarding permanent periodic alimony to the wife. This is a 30-year marriage where there is a substantial difference in the parties' respective incomes. The husband, the trial court found, earned about $175,000 as a commercial airline pilot. The wife, $40,000. It's a $135,000 differential in their incomes before alimony. After the alimony award, a $50,000 differential in their incomes. The trial court went through, to her credit, all of the statutory factors in 6130, subsection 2, and laid that out in the final judgment. Long-term marriage, identified the fact that the former wife had an issue with cancer and that she has an ongoing need for health care and medical support, that she currently has an issue with being insurable because of a cancer medication she'd been on in preceding years. By the time the COBRA expired, she would hopefully be eligible for health care insurance, but the evidence at the trial court was this was a concern, and the trial court even addressed it during the break in the trial between days. Hey, you all, how are we going to address the issue of her health insurance? But then the trial court goes on to fixate upon the former husband's mandatory retirement. There's no dispute that federal law and FAA regulations require that commercial airline pilots cease being commercial airline pilots at age 65. That was not disputed at trial. That's not disputed here. The problem is the trial court specifically zeroed in on that and said, I would otherwise award permanent alimony in this long-term marriage. The wife has an ongoing need, but he has to retire in 10 years. And because he's got to retire in 10 years, I'm going to deny permanent alimony and award her only durational alimony for 10 years, period, door closed, and acknowledges that there's going to be a several-year gap because he was 55 at the time of trial. She was 52, so she will have a 3-year gap before she's eligible for Medicare, where she will have no ability to recover alimony or support from him, despite the trial court's expressed concern on the record and in the judgment about her health and her ability to maintain insurance and her increased future medical costs.
So your position basically is at the time that the judge made this award, the judge should have acknowledged that there was a mandatory retirement at 65 and reserved jurisdiction to see what the economic status of the parties is at that time?
Essentially, that's what should have happened. I don't think the court had to make an express reservation of jurisdiction.
It's under award of permanent alimony, which is then modifiable.
Absolutely, sir. Because under the Penn decision from the Supreme Court and the progeny of cases that come from that, that's what happens.
Well, I guess the question then would have been who would have had the burden when that time came.
Right, and that's why I think this case presents an interesting issue, because a lot of times alimony appeals turn on multiple factors. Here it really turns on the issue of his mandatory retirement. It's clear from the transcript the trial court was trying to avoid the parties having to go through the burden of litigating in 10 years, but I don't think the law supports the way she chose about doing it. If we look at the Fontana case from the 1st District, which was cited in the brief, which dealt with mandatory retirement, you had a husband who was in the Navy. He had to retire in 3 years, and based upon that mandatory retirement, coupled with the belief that the wife would be able to get some income and become self-sufficient, trial court denied permanent alimony. First DCA reversed it and said just because you're going to have mandatory retirement, your retirement isn't your key to escape the alimony. You need to come back in 3 years, or in this case 10 years, if your situation has changed, to petition the court for a modification, which under 6114 he has the ability to do as to a permanent alimony award.
Because there's nothing really, even though he would retire at 65 mandatorily from American Airlines, there's nothing to prohibit him from being a private pilot for some person who might conceivably even pay him more. Is that right?
That's correct. There's nothing in the record because the trial court really can't speculate. All the trial court could say is federal law currently says at age 65 you got to leave this line of employment. There was no evidence as to anything else he could have done because that's speculative in the future. The trial court is not allowed to look into a crystal ball to speculate upon future situations, as the Supreme Court has told us in Mallard, where you're not supposed to contemplate retirement as a basis for structuring alimony, and in the Arthur case, which was on a relocation issue, but the principle that came down was family law decisions, especially these alimony and these support decisions, are present-day determinations based upon present-day evidence. The trial court denied this to lifetime support, which you would otherwise have, and this long-term marriage where all the factors lined up based upon the payor's anticipated future retirement. When you look at the PIM case, it says, yes, you have a right to retire, but that right is coupled with making sure that the recipient isn't left destitute and in peril of poverty. That's effectively what the trial court has set up for the former wife in this case, because by only awarding durational alimony, in 10 years, she does not have the ability to petition the court for additional support if she needs it.
But as part of the equitable distribution, she's going to get half of, I guess, he has a couple of pensions.
Yes, she received her marital portion of his pension and the retirements that he accumulated.
He has a pension, a defined benefit pension?
Yes, he had both that and a savings plan.
401k type thing. Is there anything that will require that he take, take those at 65? I guess maybe the defined benefit pension. You would not have to take anything out of the 401k at that point.
I don't know. I haven't studied the nuances. She received her marital portion in the judgment as part of equitable distribution. She's got her share of the assets.
Okay.
But
so she received the offset.
Correct.
Right.
But the fact that she received equitable distribution doesn't mean that when he retires at 65 and she's left at 62, that she may not have a need. She is entitled and should have been awarded lifetime permanent alimony. The alternative route that the court should at least have done, if it was trying to shift the ball to make her come to court as opposed to him come to court, would have been to award nominal permanent alimony. There's a long line of cases, starting with the Norse decision from 2007 from this court, most recently the Araya decision from this court from October 1st, where when you look at the length of the marriage, the income disparity of the parties, and the need for future support, recognized by the trial court here that she's got a need for future health care expenses, both in the transcript and in the final judgment, at a minimum she should have gotten lifetime, permanent, periodic, nominal alimony of $1 to preserve jurisdiction. The real inequity of this case is in the denial of permanent alimony, she is barred from seeking relief should she need it. And we can't know, the trial court can't know what her situation is going to be, or his situation in 10 years. And it was wrong to preclude her from what would otherwise be a statutory right based upon his situation that he will be leaving one line of employment. In the answer brief, there is a reference to a couple cases, Aquilina versus Aquilina, a 4th District case from earlier this year, and Loss versus Loss, 1998 4th District, which create an exception where the court can look into the future if there's a specific fact that we can identify as a basis for reducing or modifying an award. Those cases do not apply in this situation because when you read the language in those cases, what the courts talk about is a defined change in the need of the recipient. Both of those cases involved alimony awards predicated upon payment of money to maintain a mortgage. And when the mortgage gets paid off, the need will change, but we don't know what it's going to be, and you need to readdress it at that future point in time. None of those cases, and none of the cases that have been cited to by the Appellee, the former husband, stand for the proposition that the court can look to a future point as to the payor's ability to pay and say, that stops it. Nothing supports that. I think the structure of the law under PEM, under the Suarez case that we cited, under Fontana, is that it should have been permanent periodic alimony, and the amount that the court found was appropriate given this long-term marriage. in 10 years when he left the employment with American Airlines, he would come back to court to see if he has the ability to pay what she needs, and if she still needs the support. The burden should be on him then. But if the court finds that it wasn't an abuse of discretion to structure it the way the court did under Norse, Araya, and all of the cases that have come there, there should have been nominal periodic alimony so that the court has jurisdiction in 10 years should she have a need for support and that she's not left out in the cold. Thank you.
Thank you. Mr. Beck.
Good morning, Cynthia Hall, Silverio and Hall, representing Mr. Pern in this appeal.
Ms. Hall, let me ask you something.
Right out of the box.
Right off the bat. I've been there. The judge seemed to, obviously got a long-term marriage.
30 years.
Got a need for support.
At the time, yes.
The judge says the husband's mandatory retirement at age 65 is the basis for the award of durational alimony rather than permanent periodic alimony.
That's what she ruled.
Statute said the purpose of durational alimony is to provide a party with economic assistance for a set period of time, following a marriage of short or moderate or a marriage of long duration if there is no ongoing need for support on a permanent basis. It does not say that the purpose of durational alimony is to cut the pay or a break based on an anticipated reduction in income.
It does not say that.
So we do not, just because the husband is going to retire, that doesn't limit her ongoing need for support on a permanent basis. I mean, it's oxymoronic, is it not?
I hear what you're saying. I totally understand that aspect of the statute and the law. I think what this judge did is she looked at all of the factors here. She went beyond the factors, in fact, and did another section with additional arguments made by both sides on the alimony issue and made a comment whether she thought they were bona fide arguments or not. She really did a good record here for this court of all of her findings under the statute. But what's forgotten here is that Pym talks about involuntary retirement as opposed to voluntary retirement. So in our
I'm concerned about just kind of looking down the road and essentially having a modification. What we would have used to would have been a modification, a predetermined modification based on future circumstances.
Right. But I think in this particular,
but if we were to, the statute had not become so complex. The way we did it in the old days, I hate to put it that way. But I mean, there was all sorts of case law that said, look, even where you have a recipient or someone who was requesting alimony, who is currently capable of self-support, but has an issue, generally a health problem, that creates the very real possibility that they're not going to have that self-support, capability of self-support down the road, that the option is left open with a nominal alimony award so that if, heaven forbid, the worst happens, they can come back and address that situation.
this court, my case, Perkovich, Humphrey case, out of the Second District Court of Appeal, where the wife was employed, making a very good income, but had a health issue, and the court reserved $1 a year in permanent alimony in case she became unable to work. I'm familiar with those cases.
So this judge has just totally foreclosed that based on an assumption that he's not going to be able to afford to pay alimony when we don't know that's the case, because he might, as Judge Morris suggests, step off. He might be Derek Jeter's pilot.
Could be.
You know, landing in Derek Jeter's backyard.
And I think speculating, the court was bound by the record that they were given, the evidence and testimony produced. There was no testimony or evidence at trial of what this husband would do post-retirement. They didn't do a vocational evaluation. They didn't suggest pilots' incomes.
So what the judge said was assumed that it would be zero.
The judge, I presume what she said, basing the record, and I was not the trial attorney, But the judge divided all of the substantial retirement accounts
Understandable.
and the pension accounts, which would kick in and each party would be receiving 1/2 of the income at that time.
Right.
The court found that the wife was earning around $40,000 per year, but in prior years she had earned significantly more income. So if you look at all of it, I think the court took into consideration the age here, which is never addressed by the appellant. Age 65, that's what he'll be when he mandatorily retires. So under PIM, it's a mandatory retirement, not voluntary. PIM says you can voluntarily retire. You can't do that just to avoid alimony. I understand that law. And there are other cases that dealt sort of with this issue, like the Fontana case. However, that gentleman, the payor in that case, was going to be 47 years of age, not 65 years of age. So I think the court, and I'm reading into the record here, figured that we're dividing all of the assets now, 50-50, significant retirement accounts which will spill off income to both parties equally. The man will be 65 years of age, and it's mandatory he retire. He's not voluntarily doing it. It's
Retire
mandatory.
from one job.
From his job, the only job. There's no testimony he's ever had another job. He could do anything else. In the record, took all of that into consideration. And I think it is a concern that there's a shifting of the burden. If the court had awarded permanent periodic alimony of $3,500 a month, when he mandatorily is forced to retire, then he must bring an action.
Right,
And
understandable.
I'm sure the argument.
And I will tell you, if the question, if you were here complaining of that, or if the judge had ordered nominal and he was here complaining of that in terms of the burden shifting, I'm thinking, you know what, that's going to be the judge's discretion. I don't care. But this woman is totally cut off at that point.
I understand.
And for all we know, she may be under breast cancer treatment by then and not able to work and have very large medical bills.
She may.
And
She may qualify for Social Security. She may have health insurance through her employer.
The only thing we know is that he will have to leave his present job. And that's all we know.
And we also know that there is no evidence or testimony that there is any other income available to him other than the retirement
Or
accounts.
not. I mean, we don't know the other.
Or not.
Right.
Or not. We don't know whether the
We're
wife
looking
will.
10 years down the road, and the
I
law
hear you.
cautions us not to do that.
I hear you. I also, there's no testimony or evidence is the wife going to be making in excess of what the husband is now.
True.
And then we have a husband who's retired living on his retirement benefits. We don't know.
That's why
You're
we
right.
try not to put things in concrete.
I understand.
At the risk of
Yes.
saying we would be speculating, would it have been, it would have been the wife's burden below to provide evidence of what he had done or what he could do,
Absolutely.
and she didn't
She did not.
proffer anything. Of course,
And they
anything,
conceded age 65 was mandatory retirement. They didn't put on any case. They didn't put anything at all. And so now what they're arguing to you is to reverse.
Well,
And-
the judges use durational alimony for a purpose that is not its purpose in the statute.
Well, the court didn't find that permanent periodic alimony in this particular case was the sole
No, she
appropriate
said
method
that's-
either.
She said his retirement at 65 is the reason why she's awarding durational instead of permanent periodic.
I understand, but I also.
So I think that kind of says it. I mean, that's pretty clear.
I hear what you're saying. I think in other portions of the transcript, I think you can read that she didn't go to the point where she made a finding that permanent periodic alimony would be appropriate and the sole type of alimony unless, I've lost my track.
Right,
I
that's okay.
apologize. You know what I'm saying? With this mandatory retirement here, that's why I'm not awarding permanent alimony, because that's the sole reason. She didn't go that far. I don't know whether it's because she rested on her decision that it's a 10-year alimony case based on the mandatory retirement.
I think she kind of made that clear. I mean, that statement's pretty clear.
She says it more than twice.
If she,
In the final judgment itself.
if she doesn't award any alimony, she says, "Look, I'm not awarding any alimony because he's going to retire in 10 years." I think there's a reversal here, correct?
Absolutely. Under this
Absolutely.
fact
You
pattern.
got a present
on
huge
the income.
disparity in income. You get, et cetera, and so forth.
I agree with you completely. And I also, on the durational alimony, I saw the second point on appeal. We all represent our clients,
Yes.
but the law says what it says. I mean, I don't know why that add-on sentence was there. I don't know why it wasn't cured by rehearing. I don't have an explanation for that language, but the judge put in there, and I acknowledge that to the court as well. I think that based on this particular record and the work that the judge went into, the court is not supposed to step in the shoes of the trial court and reevaluate. I'm not going to argue all those cases to you all. You all know it, inside out. You're not supposed to reverse when the court's done all the work that they're supposed to do. I would suggest that if the court was going to do anything with regard to this opinion, that it be with specific instructions to award $1. Otherwise, what will happen. This will be a reversal to the trial court for another full trial. You saw a lot of the findings and problems that were in this final judgment that this family went through. And I would think that there are remedies that are less severe than just a reversal for a new trial, and I would urge the court to consider that. Are there any other questions? I think you covered everything in my brief.
You did well.
Thank you, Judge.
Your Honors, we don't have to remand for a new trial. The appellant didn't challenge the amount of the alimony. The issue that was challenged was the decision permanent versus durational. This court can remand and instruct to award permanent alimony the amount that the trial court found was appropriate. This court can reverse and require nominal alimony of $1. None of these options, I think, require a new trial and the parties to go through that expense. It's not what we were contemplating. And Judge Northcutt, you're correct that the basis under which the durational alimony was awarded is expressly in conflict with the statute. Permanent alimony is to be awarded unless the court finds it's not appropriate. You look at the section on durational and it says in a long-term marriage, if there's no ongoing need for support, not the payor is going to retire in 10 or 15 years or however long it's going to be. As to the evidence of post-retirement income, that's all speculation. We're not supposed to put on evidence today of what the world's going to be in 10 or 15 years. That's why there really was nothing and why we award permanent alimony or reserve jurisdiction so that when those events occur, the parties come back and deal with it in real-world terms, present evidence terms. And so the fact that there was no evidence of what he could do in the future, any speculative evidence, that really has no bearing on here. Look at the Suarez case again. That is a case where an 81-year-old went to retire. Permanent alimony had been awarded. The trial court said terminated. The appellate court, the third DCA said no. He's got pension income. He's got Social Security income. You fail to show he can't pay anything in support. She still has an unrequited need that you didn't prove she didn't have. That determination of what his ability to pay is going to be in 10 years and her need in 10 years, that's why we need to have the preservation of jurisdiction, whether it be through the permanent alimony award where he has the burden to come back, or the reservation of jurisdiction to the nominal alimony award where she's got the burden to come forward. But we can't close the door on this woman in 10 years and say after a 30-year marriage, you're on your own. That's unfair and it's an abuse of discretion. We ask the court to reverse and send back down. Thank you.
Thank you, Mr. Thatcher. Thank you both. Travel safely. We'll take a little break. Yeah, we're gonna take a 10-minute break.
5 minutes.
5 minutes. I'll pass you your up.
He's going to be back here.